Welcome everyone. Thank you for joining our masterclass about the Brazilian data protection law. Before we start, we'd like to introduce ourselves. My name is Cinira Teixeira. I am a certified DPO and IAPP certified Information Privacy Professional Europe, CIPPE. I am a data protection lawyer at MyData-TRUST, and today I will present with my colleague Idriss.
Hello everyone, I'm Idriss Awagoum Yonta. I'm data protection lawyer at MyData-TRUST, and we are both working on the implementation of Brazilian data protection law.
MyData-TRUST is a company specialized in privacy and data protection for the life science industry. We have offices in 6 countries: Belgium, France, the US, UK, Romania, and now also Mexico. And we provide services to clients worldwide. And we offer a full range of data protection services to ensure our clients' compliance to the data protection law. And today we are really excited to have this opportunity to give you an overview of the Brazilian data protection law and to discuss the main requirements to be compliant. Our goal today is to address the main questions you may have about the Brazilian data protection law, focusing on the life science industry. And our main question today is, are you compliant with the Brazilian data protection law? As you may know, the Brazilian law entered into force in 2020. So why to discuss this and ensure the compliance now? To understand that, we should have an introduction and have a look at the evolution of the law. The Brazilian data protection law is called LGPD, which is the abbreviation in Portuguese for General Data Protection Law, and it's the first comprehensive data protection law in Brazil. It was inspired by GDPR, so many of the concepts are the same, but of course there are some local peculiarities. The law entered into force in 2020 after 2 years of transition period, but it entered into force only partially because the enforcement measures were postponed to give companies more time to adapt. So the enforcement measures entered into force in August 2021, but at that time we didn't have the criteria to apply the sanctions. That's why we didn't have any sanction applied until this moment. But this may change soon. Since February this year, the Brazilian Data Protection Authority, called ANPG, published a resolution regulating the criteria to apply the sanctions. And more recently, they also published a list of companies that are under investigation, which includes some Brazilian public entities, but also companies such as WhatsApp and Facebook. So we expect the first sanctions soon. We'll talk more about the sanctions later in this presentation. And the question is, who is impacted by the law?
Well, to comply, first you have to know if the law applies to you or not, which brings us directly to the question of the scope of application of the LGPD. This scope is quite similar to that of the GDPR. Generally, we can say the law applies to any processing activity carried out by a natural person or legal entities, irrespective of the means, the country in which its headquarters is located or the country where data are located, provided that the processing operation is carried out in Brazil, the data processes was collected in Brazil, the data subjects are located in Brazil, or the processing activities is the aim at the offering or provision of goods and services to data subjects located in Brazil. To summarize, we can say that when data processing activities of a natural person or legal entities involve personal data of Brazilian citizens or persons located in Brazil, the LGPD applies. Also, this law doesn't set a size threshold. This means for all companies specialized in the life science sector that they will need to comply with the legislation. Another important point to note here is that, like the GDPR, anonymous data doesn't fall within the scope of the LGPD. We can use some examples to better explain the scope of application of this law. Basically, an organization based outside of Brazil will be subject to the LGPD if it processes personal data that was collected in Brazil, if part of its data processing takes place in Brazil, or if it intends to offer goods and services to data subjects located in Brazil. And more specifically to the life science sector, if company process personal data of data subject located in Brazil, this is the case, for example, in clinical trial, he will be subject to the law. Or if the data processing of the company take place in Brazil, for example, by using a laboratory based there, or if it uses a server which is located in Brazil, typically a CRO using a cloud service provider based in Brazil. In all these situations, the LGPD will apply to your organization. Another important point to know here is that in the context of clinical trial, a sponsor based in the European Union who is already subject to the GDPR, who wish to extend or to conduct a new clinical trial in Brazil would need to comply with the GDPR and the LGPD. This means both legislation will apply to its data processing activities. Now you know more about who must comply. So what are the main requirements?
Well, when you talk about the main requirements, I think the first aspect to consider is, do you need a legal basis to process data in Brazil? And the answer is yes. According to the LGPD, the processing of personal data is only authorized under the legal basis provided by law. The same way as GDPR, LGPD provides legal basis for processing of general data and a specific legal basis for processing of sensitive data, and health data is classified as sensitive data. Here we will focus on the legal basis for clinical trials. So according to the law, the appropriate legal basis to process health data is consent. And this consent must be informed, specific, distinct, and for specific purposes. So the concept is aligned with the concept in GDPR. We can also rely on legal or regulatory obligation as long as the processing is provided by a law or regulation with effect in Brazil. And just to clarify one aspect that may cause some confusion, the law also mentions that consent is not necessary for studies conducted by a research body. However, the law defines research body as a public entity or a non-profit private entity. Therefore, we cannot rely on this legal basis for the processing of data in clinical trials conducted by the industry. Another issue we face regarding clinical trials is the international data transfer. According to LGPD, transfer outside Brazil requires the implementation of certain mechanisms to guarantee the same level of protection. These mechanisms are similar to the ones mentioned in GDPR. However, the Brazilian law does not establish any hierarchy between them. So first, we'll have adequacy decisions, meaning that we can freely transfer data to countries that are considered adequate according to a list to be published by the Brazilian Data Protection Authority. Then, for countries that are not adequate, we have to implement appropriate safeguards, which includes standard contractual clauses, binding corporate rules, certification, codes of conduct, the same ones mentioned in GDPR. And the LGPD also authorizes the transfer when the data subject provides his consent. The main issue here is that so far we do not have a list of adequate countries. It's not been published by the Brazilian Data Protection Authority. And also, the authority has not issued the standard contractual clauses. So, for the moment, we have to rely on consent for data transfer. Please note that this consent must be informed and specific. That means, for clinical trials, that the ICF must be adapted to collect the consent for the transfer, and also informing the purpose of the transfer and to which countries the data will be transferred. And the Brazilian law does not require a transfer impact assessment. And another recurrent question is, do we need a DPA?
Oh yes, it is mandatory, and I will even say that the first critical step toward LGPD compliance is to appoint a data protection officers. However, there is an exception which exempts small companies from having a DPO. But it should be noted that this exception does not apply when the processing of personal data concerns sensitive data. This means in practice that for all companies involved in clinical trial sector, having a DPO will always be mandatory. Another interesting point is to see that the data protection officer in the Brazilian General Data Protection Law have the similar role that the DPO in the GDPR. Mainly, he will act as point of communication. It should be noted also here that there is no need to notify your data protection officers to the national supervisory authorities as is the case in the GDPR. Another one important topic is to know that there is no notion of data protection requirement in the LGPD. This means for all companies located outside of Brazil that are subject to the LGPD, there is no requirement to appoint a specific data protection representative in Brazil, as it is the case in the European Union for non-EU companies, non-EU-based companies that are subject to the GDPR. Another main requirement of the LGPD is the record of processing. The controller and processor must keep a record of processing activities, but you should pay attention because this record of processing activities must be made in Portuguese. About data subject right, like the GDPR, the LGPD grants data subject with certain rights to enable them to better keep control over the way their personal data are processed. These rights are sensibly the same as those in the GDPR. Mainly, you will talk about the right of information, the right of access, rectification, the right of portability, withdrawal of content, but care must be taken because the time limit to respond to such requests are not the same. For example, an organization has 15 days to respond to the request of access by a data subject. This means in practice that your company must put in place a data subject right procedure to better handle the request of the data subject in a timely manner. Another big question we should have is, what about data breach?
In case of data breach, the procedure is similar to the one provided by GDPR. The controller must notify the data protection authority and the data subjects when a security incident may create risk or relevant damage to data subjects. The notification to the data protection authority must be made through a form that is available at the Data Protection Authority website and in Portuguese. And here we have a difference. The deadline to notify is 2 working days. And according to the seriousness of the breach, the NPD may determine a broad disclosure of the event in communication media or measures to reverse or mitigate the effect of the incident. And so, what happens in case of failure?
It should be noted that breaches of the provision of the LGPD can result in the fines up to 2% of the sale revenue of the legal entity in its last fiscal year, excluding taxes, up to a total maximum of 15 million Brazilian real, approximately 10 million euros. It is also important to know that the National Supervisory Authority can also issue warning or decide to block the data processing activities. Or in the event of repeated violation of the LGPD, the sanction may range from the total or partial suspension of the database to a total or partial prohibition of the activity concerned. The civil liability of the company may also be engaged because processor or controller who cause material or moral damages to a data subject providing for the violation of the LGPD must redress it. It is also important to keep in mind the LGPD provision regarding vendor management, where data processor must act according to data controller instruction. As a result, a data processor will be jointly liable for any damages caused by the processing if the data processor fails to comply with the obligation of the LGPD or fails to follow the lawful instruction of the controller. It's also important to note that the data controllers that are directly involved in the data processing are jointly liable. And keep in mind that judge may reserve the burden on proof in favor of the data subject. All these sanctions may cause reputational damage to your organization. To avoid this kind of sanction, what are the main steps to follow?
Well, considering these enforcement measures, it's really important to ensure the compliance to the law. And how to do that? Well, your action plan will depend if you are already GDPR compliant or not. If you are GDPR compliant, you already have the main notions, but still have a lot of work to adapt your procedures and tools. If you're not GDPR compliant, then you have to implement all the procedures and tools required by the law. For instance, to start, we have to review or draft your privacy notice to ensure that you can provide the information to the data subjects that are required by law. When contracting a processor, the Data Protection Authority recommends to have a contract establishing the responsibility between the parties. You also have to implement the appropriate data transfer mechanisms and to designate a DPO. Besides, you have to draft or review your internal procedures to ensure that you can timely respond in case of a request. You may also keep a record of the processing activities. And we strongly advise to raise awareness by providing training to your staff. And there is an important aspect to keep in mind. There are many topics in the Brazilian data protection law that require regulation. The Brazilian Data Protection Authority, ANPG, is being very active, so we expect new resolutions to be published in the next months, and which may raise the need to update your procedures in order to remain compliant. And MyData-TRUST can support you in this process.
Good. This brings us to the end of our presentation. What we need to keep in mind is that the LGPD is a new piece of legislation, strongly inspired by the GDPR, but which still has its own particularities. Compliance with this new legislation is not really evident. The National Data Protection Authority is actively publishing guidelines to support the implementation of the law. But at this stage, we are still waiting more guidelines to better explain how organizations should put in place all the requirements of the LGPD. And particularly in the life science sector, where several other pieces of legislation need to be taken into account, the application is a little more complex and difficult to put in place. But MyData-TRUST is here to support you. As we are a team specialized in the field, we will provide you with all the elements necessary and all the tools you should put in place to be in compliance with the Brazilian General Data Protection Law. We would like to thank you for your time and your attention today. For more information and interesting news, feel free to follow us on our social media page by using the QR code on the screen. We will be there to support you. And thank you to attend to this masterclass.
Thank you. And now let's check if you have some questions in our chat. Let's see. We have a question about, I can see a question about the PIA. Do you need a DPIA?
Yes, for the DPIA, let's say that is provided by in the law. But currently, the National Supervisory Authority has the power to ask to a data controller to perform a data protection impact assessment in certain circumstances. But recently, last April 2023, the INPD published on its website a Q&A about the data processing impact assessment. And in this Q&A, the INPD strongly recommends the data controller to perform a DPIA in any context in which the data processing activity may pose a high risk to the civil liability and fundamental right of the data subject. This means it's a case-by-case analysis. As we are in the life science sector and we are processing sensitive data, the likelihood to be in a high risk is really enormous. So I will say we recommend the company in the life science sector to perform a DPI for the processing.
Let's see, we have another question here about pseudonymized data. Is pseudonymized data covered by the legislation? Well, about the subject, the concept is the same as GDPR. Anonymized data is not under the scope of the law, but pseudonymized data, yes. And the concept of pseudonymized and anonymized data is the same as GDPR. So we do not have any new guidelines about pseudonymization or anonymization, so we're following the law, and according to the law, that is the concept. I do not see any other questions.
It's like we face.
Oh, do you have one here?
Yeah.
What if the sponsor is non-profit? Would the consent be required? Oh, well, that we have to check. The sponsor is non-profit, but the research is aiming to develop a new medication that will aim to profit. Then we have to check the case by case, the concrete case, to see if that is, in the end, the goal is to have profit, and then see if it applies. As we said, we do not have many guidelines published, so far we're still waiting for more guidance from the Data Protection Authority for many questions that are related to clinical trials.
Yes, if we do not have another question, we thank you for your time, for your attention, and feel free to contact us if you need support for your activities. We will be there to provide you the good support. Thank you for attending this masterclass.
Thank you.